There's a fascinating story playing out in court after a person who used to work for the airline Airlink has now moved to SAA. Airlink is claiming she's taken confidential commercial information with her. Airlink claims Carla de Silva has information around ticketing and pricing that they believe is confidential. They want SAA to not use that information. SAA says it won't comment on the issue because it's before the courts. Phuthego Mojapele is an aviation analyst. Phuthego, good afternoon to you. I love this story. How important is the ticketing and routing and pricing information, the strategies of airlines to those airlines? How important is it for them?
Well, it's important because it is in the bone of what the airline should be make out of. Airlink has cited that there was quite an important clientele, the database of clientele that they had, which Ms. Da Silva had an opportunity to control that clientele. Some of those clients were approached, and they also went back to Airlink and say that their former employee had been approaching them to try and solicit some business which belongs to Airlink, and therefore Airlink saw it fit that I think it would be important for them to approach the court. But they just did not do it. Only that, there was a couple of attempts for the Airlink to approach SAA to say, look, let's discuss this matter before we can go to courts, before we can get our legal team start talking to courts and so on. But it looks like SAA was not interested in entering into any negotiations with that regard.
I mean, SAA could just have said, yes, we've hired your former employee, but no, she hasn't brought any confidential information with her. And they didn't say that.
Well, Airlink didn't just say it that way. I think if you were to be fortunate and get into the documents that were filed before the court, there is a special investigator who Airlink hired to look at how the information was transferred from Airlink computers to a private device that was then circulated among the sales team of South African Airways. As you can see on the court documents, there's about 12 respondents, which is the people that information, according to the court papers of Airlink, were distributed to those salespeople at the SAA. And therefore, they felt that it is important that this matter get ventilated through the courts. But it is not only the issue that the person was working for SAA. I think what is important here is that there's a trail of information that was obtained by Airlink that suggests that indeed their clients were approached, and therefore they do have a case to answer, because some of the important information that's there, it's personal information which is obviously been regulated in South Africa, and therefore they thought that it is important that they deal with it before the courts.
I imagine, Phuthego, that Airlink would be quite keen on some of its clients complaining to the information regulator under the POPI Act about that kind of thing. I mean, all of this could get quite messy.
Yeah, it will get what SAA should have done here, because all of us, you can work for any other company. What is important for SAA would have done here was for the CEO, because he was the first person to be approached about this matter, and he did nothing about it. SAA doesn't need a bad press at the moment. I think it needs more to be stable and not being tangled into things like that. I think they should have been proactive. When Roger approached Professor Lamola with this issue, Professor should have listened to him, and it shouldn't be here. At this stage, I think SAA was really not, I think they should resolve it out of court. Otherwise, it's going to be a bit messy, as you alluded now, that National Information Regulatory will get involved as well, and because that's some of the important and personal information that was shared in that document.
I'm sure, Phuthego, there'll be a Labour lawyer, a Labour case here as well, because, excuse me, if you sign a contract with one employer. You can't take their confidential information, whatever it may be, and all contracts have this. You can't take their confidential information to a competitor. I mean, that's how it works.
According to what the court papers are saying is that some of that information was shared with SAA before she could leave Airlink, meaning that she was already in breach of her employment contract by the virtue of soliciting the information of the clients that belongs to Airlink while she was still in employment of Airlink, and therefore I would imagine that she was already in breach of her employment contract. And I think what was needed there to happen was, as Airlink was requesting the meeting to resolve this matter, it should have been dealt with at that particular time. But they probably have strong lawyers that would argue this matter differently. But as far as the court documents that we have seen, I don't know how it's going to be turning out in their favor, because clearly there was a couple of bridges that were there, because they went as far as hiring a private investigator who has a vast experience to show that this information was illegally obtained and it was transferred illegally as well. So we will see how it goes.
It's very interesting. Phuthego, I mean, this isn't the only court case you're seeing with our aviation industry at the moment. There are a couple of airlines, I forget the names now, but they're suing SAA over its ownership structure. They say it's not majority owned. It's got to be 75% owned by South Africans to operate in our airwave, in our airspace. What does it say when people in an industry like ours are all suing each other, or are they all fighting for a bigger piece of a small pie?
Well, the matter here between, again, is Airlink as well as Global, which owns Lyft. And they went to the council to say the 74% of SAA is owned by foreigners, which means that they have exceeded the threshold of ownership of a foreign ownership of the airline, meaning that they are now competing unfairly, because they, Airlink as well as Global, they have a minimum shareholding of foreign ownership. So this is a law, unfortunately, that needs to be tested before, there's a regulation that needs to be tested before the council, and it's going to be sitting on the 11th of this month, where we are going to hear the council arguing and with the lawyers of the both Airlink, SAA as well as Global. But one should say the competition is very rife at the moment. You have Airlink that has been competing in between Cape Town, here in Cape Town, to Mpumalanga, Kruger, and SAA today has now launched a service to Mpumalanga, Kruger, offering almost a fraction of a cost of what Airlink has been offering. So you can tell that competition is becoming very rife, and people are fighting for their space, and it's going to be a little bit messy with these things are going to be playing out in courts, and one can only say that it is good for us consumers for competition to be there, and it's good for the industry will grow, but as to whether playing in the courts and exposing each other, it's a little bit messy there.
Phuthego Mojapele, thanks very much indeed. Always appreciate the time, the aviation analyst.